defendant, Derrick Coles, is charged in counts 1, 2, 3, 4, 5, and 6 of the indictment with the offense of injury to a child alleged to have been committed on or about the 6th day of February 2022 in Bexar County, Texas. To the offenses, the defendant has pleaded not guilty. The state has waived and abandoned count 3 of the indictment. Count 3 will be dismissed. With regard to the remaining counts, you are instructed as follows. Our law provides that a person commits the offense of injury to a child if the person intentionally, knowingly, or recklessly, by act, causes a child serious bodily injury or bodily injury. Child means a person 14 years of age or younger. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any body member or organ. Act means a bodily movement, whether voluntary or involuntary. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Count 1. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Bexar County, Texas, the defendant, Derrick Coles, did intentionally or knowingly cause serious bodily injury to Danilo Coles, a child who was 14 years of age or younger, by forcing Danilo Coles to engage in prolonged exertion, then you will find the defendant, Derrick Coles, guilty of the offense of injury to a child as charged in count 1 of the indictment. Skip paragraph 5 and proceed to paragraph 6. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of injury to a child as charged in count 1 of the indictment, and proceed to paragraph 5 to next consider whether or not he is guilty of the lesser included offense of recklessly causing injury to a child. Paragraph 5, count 1, lesser included offense of recklessly causing injury to a child. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February of 2022 in Bexar County, Texas, the defendant, Derrick Coles, did recklessly cause serious bodily injury to Danilo Coles, a child who was 14 years of age or younger, by forcing Danilo Coles to engage in prolonged exertion, then you will find the defendant, Derrick Coles, guilty of the lesser included offense of recklessly causing injury to a child in count 1. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of recklessly causing injury to a child in count 1. Paragraph 6, count 2. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February of 2022 in Bexar County, Texas, the defendant, Derrick Coles, did intentionally or knowingly cause serious bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with a belt, or by burning Danilo Coles with water, or by striking Danilo Coles with the hand of Derrick Coles, then you will find the defendant, Derrick Coles, guilty of the offense of injury to a child as charged in count 2 of the indictment, skip paragraph 7 and proceed to paragraph 8. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of injury to a child as charged in count 2 of the indictment, and proceed to paragraph 7 to next consider whether or not he is guilty of the lesser included offense of recklessly causing injury to a child. Paragraph 7, count 2, lesser included offense of recklessly causing injury to a child. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did recklessly cause serious bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with a belt, or by burning Danilo Coles with water, or by striking Danilo Coles with the hand of Derrick Coles. Then you will find the defendant, Derrick Coles, guilty of the lesser included offense of recklessly causing injury to a child in count 2. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of recklessly causing injury to a child in count 2. Paragraph 8, count 4. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did intentionally or knowingly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with a belt, then you will find the defendant, Derrick Coles, guilty of the offense of injury to a child as charged in count 4 of the indictment, skip paragraph 9 and proceed to paragraph 10. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of injury to a child as charged in count 4 of the indictment, and proceed to paragraph 9 to next consider whether he is guilty of the lesser included offense of injury to a child. Paragraph 9, count 4, lesser included offense of recklessly causing injury to a child. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did recklessly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with a belt, then you will find the defendant, Derrick Coles, guilty of the lesser included offense of recklessly causing injury to a child in count 4. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of recklessly causing injury to a child in count 4. Paragraph 10, count 5. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did intentionally or knowingly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by burning Danilo Coles with water, then you will find the defendant, Derrick Coles, guilty of the offense of injury to a child as charged in count 5 of the indictment, skip paragraph 11 and proceed to paragraph 12. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of injury to a child as charged in count 5 of the indictment, and proceed to paragraph 11 to next consider whether he is guilty of the lesser included offense of injury to a child. Paragraph 11, count 5, lesser included offense of recklessly causing injury to a child. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did recklessly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by burning Danilo Coles with water, then you will find defendant Derrick Coles guilty of the lesser included offense of recklessly causing injury to a child in count 5. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of recklessly causing injury to a child in count 5. Paragraph 12, count 6. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did intentionally or knowingly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with the hand of Derrick Coles, then you will find the defendant, Derrick Coles, guilty of the offense of injury to a child as charged in count 6 of the indictment. Skip paragraph 13 and proceed to paragraph 14. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of injury to a child as charged in count 6 of the indictment, and proceed to paragraph 13 to next consider whether he is guilty of the lesser included offense of recklessly causing injury to a child. Paragraph 13, count 6. Lesser included offense of recklessly causing injury to a child. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 6th day of February 2022 in Berry County, Texas, the defendant, Derrick Coles, did recklessly cause bodily injury to Danilo Coles, a child who was 14 years of age or younger, by striking Danilo Coles with the hand of Derrick Coles, then you will find the defendant, Derrick Coles, guilty of the lesser included offense of recklessly causing injury to a child in count 6. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of recklessly causing injury to a child in count 6. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment, and not so remote that the prosecution of the offense is barred by limitation. The statute of limitations for the offense of injury to a child is 10 years from the 18th birthday of the victim of the offense. The indictment in this case was filed on September 25th, 2023. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas, or the Constitution or laws of the United States of America, shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe, or if you have a reasonable doubt, that evidence was obtained in violation of any provisions of the Constitution or laws of the state of Texas, or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. You are instructed that a statement made by the defendant is to be wholly disregarded and not to be considered for any purpose whatsoever by the jury if the following 3 circumstances exist. 1, the statement is given as a result of custodial interrogation. A person is considered in custody only if, based upon the objective circumstances, a reasonable person would believe he was restrained to a degree associated with a formal arrest. B, custodial interrogation is defined as questioning initiated by someone in the role of a law enforcement officer after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. C, Custodial interrogation exists when a reasonable person would have believed he was not free to terminate the interview and leave. D, in determining whether a person is free to leave, the following factors are considered. 1, whether probable cause to detain the person existed at the time of questioning. Probable cause exists when facts and circumstances within an officer's knowledge and about which he has reasonably trustworthy information sufficient to warrant a person of reasonable caution to believe that an offense was or is being committed. 2, the subjective intent of the officer or functional equivalent of a law enforcement officer doing the questioning. 3, the focus of the investigation. And 4, the subjective belief of the individual being questioned. 2, and prior to making such oral statement, the accused was not given the following warnings by the person to whom the statement is made. A, that he has the right to remain silent and not make any statement. B, that anything said by the defendant will be used against him at trial. C, that the statement will be used against him in court. D, that he has the right to terminate the questioning at any time during the interview or questioning. And E, that he is entitled to the services of an attorney, his own, or if he is unable to employ one, a court-appointed attorney to advise him prior to and during any questioning or interrogation. 3, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. A defendant's statement may be considered involuntary when there is overreaching in the form of official, coercive conduct by the person doing the questioning of such a nature that any statement obtained thereby was unlikely to have been the product of an essentially free and unconstrained choice by its maker. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose, nor any evidence obtained as a result thereof. You are instructed that during the videotape, there is questioning by a police officer. The questions that the officer asks are not offered as, nor admitted for, the truth of the matter asserted. That means that what the officer says or asks is admitted for the purposes of assisting you, if it does, to put the matters in context. When the officer is asking questions that assume facts, you are not to consider those questions as truth, but only as part of the interrogation in the context of the interrogation. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and utilized by the prosecution and the defense for purposes of cross-examination or for purposes of refreshing a witness's memory are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by the evidence, or statements of law made by counsel, if not in harmony with the laws as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate any information about this case or to conduct any research about this case until I accept your verdict. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After you have retired to your jury room, you should select one of your members as your foreperson. It is his or her duty to preside at your deliberations, vote with you, and when all 12 of you have unanimously agreed upon a verdict, to certify to that verdict by signing the same as foreperson. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be unanimous, in writing, and signed by your foreperson. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the foreperson, and submitted to the court through the bailiff. Respectfully submitted, Judge Joel Perez, 437 District Judicial District Court, Bexar County, Texas, and it has verdict forms if you care to use them. Is the state ready for argument?
Sorry.
Is the defense ready for argument?
Yes, sir.
Okay, go ahead, State, you may proceed.
Thank you. Good afternoon, ladies and gentlemen of the jury. You just heard the judge read all of the law that is applicable to this case and that you should use during your deliberations. As he said, you didn't have to memorize all of it because you will have this packet in front of you when you're back there deliberating. I kind of want to break it down for you because there was a lot in what said and a lot included in it. This is the charge, and when you go through it, don't be scared of it. And I want you to look at the breakdown of all of the counts that are going to be what we are asking you to decide in this case. The biggest thing that I want you to remember, specifically from voir dire, from when my partner Willem was talking to you guys about the mental states of the defendant, right? How it is charged now, count one of the indictment has whether this defendant intentionally or knowingly caused serious bodily injury. Right? That count as it is charged right now is the first degree felony. When we're looking or asking you to look at whether he intentionally or knowingly caused this serious bodily injury, if you so find that he did not, then it is when you go into the second paragraph, this is the next page, and that one talks about the mental state of recklessness. Willem also mentioned how that brings it down a degree in terms of punishment for injuries, right? It'll be the second degree felony. And so when you go through these, it'll be the same exact thing for each and every count, except different degrees of felonies, right? So count one, if you so find that he did it reckless, then it becomes a second degree felony. Count two is the same thing. If you so find that it was not intentionally or knowingly, but you do find that it's reckless, then it becomes a second degree felony. The same thing with count 4, 5, and 6, except that those are actually third degree felonies, right? And so those mental states again are intentionally or knowingly. If you find out that it wasn't those two, but you find that it was reckless, then it becomes a state jail felony. And so these pages break all of those instructions down. And so if you do have a question regarding all of that, go ahead and please refer back to it because it tells you exactly where to go if you find that it's one or the other. Okay. The other thing that I wanted you to pay attention to in these specific counts is that and I used it right now, right? Intentionally or knowingly, right? The judge mentioned how you do have to be unanimous in each and every one of your verdicts in the verdict forms. However, you do not have to be unanimous in the mental state that you believe that this defendant committed such actions, right? So if 6 of you believe that he did it intentionally and 6 of you believe that he did it knowingly, the fact is that you still believe that he committed this crime, and so the fact is that you should find him guilty of that. And so that would be the same thing in each and every count for the mental states when it has the or in between, right? It is a list, but the or means that you guys don't have to be unanimous in that specific instance. Then there's another instance where that happens in count 2 specifically, where we list out several different what we call manner and means, right? So whether this defendant inflicted serious bodily injury onto Danilo Coles by striking with a hand or by burning with hot water. And so what I would like you to point out is, again, if you believe that this defendant caused serious bodily injury to his own son, Danilo Coles, by inflicting, by spilling hot water on him, 6 of you believe that, but 6 of you believe that he struck him with a belt and that was what caused serious bodily injury, and the fact still remains the same, that you believe that this defendant caused that serious bodily injury. You do not have to agree on what specific instance caused that serious bodily injury, if you do believe that it happened. Okay? so, the other thing that I wanted to point out is that this charge also explains that when you have a question for the court, it must be addressed in writing. The one thing I did want to mention is that that question has to be pretty specific. So the best example I can give you is, let's say that three of you believe, this is a metaphor, three of you believe that when there was testimony, they testified that the car was blue, but three other jurors believe that the car was red. But you guys are disagreeing about what was actually said during testimony. And so the way that you would ask that question is be specific about what particular point of the testimony you guys disagree about or on, and ask the court in that specific manner, okay? Again, that has to be in writing through your foreperson, and the court will receive that question. Now, the other point that I wanted to make, and it's addressed here, and we've addressed it since the beginning of this case through Ward Dyer, is that the state of Texas, or the state, has a burden of proof. And like we mentioned, we welcome that burden, and we do believe that we have went ahead and proved every element beyond a reasonable doubt in each and every count. I want you to remember that Willem put up there in his PowerPoint during Ward Dyer 3 specific questions to ask yourself when you're deliberating. You have to ask yourself, do I have a doubt? And if you do, then you move on to whether that doubt is reasonable, and then whether or not that doubt goes to one of the elements of the crime. That's the specific portion. You have to see whether that doubt is in one of the elements of the crime. And so when you're back there, again, there are different counts, and I don't want you to be scared of those counts, right? They sound like a lot of legal jargon. But what you do, like Willem had it in his PowerPoint, break them down, right? So there are different parts of the element or of the charge. For example, there are some that are uncontroverted, right? Let's say count 2. On or about a certain date, right? In this particular instance, February 6th of 2022. This defendant, Derrick Coles, did then and there intentionally and knowingly cause serious bodily injury to Danilo Coles, a child younger than 14 years, by striking the complainant with a belt, by burning the complainant with hot water, or striking the complainant with the hand of the defendant. Now, some of those elements are uncontroverted. You heard testimony from different kinds of witnesses that proved our elements, or we proved our elements through them, where on or about the 6th day of February, everyone came in here and said that that is when Danilo went to the hospital because of these injuries. You know that it was Derrick Coles because we also had some witnesses come in and identify the defendant as Derrick Coles, as Danilo Coles' biological father, the person who was supposed to protect him, as the defendant in this case, the one who inflicted those injuries. Now we go into the intentionally and knowingly portion, and that's what we're going to have you guys deliberate. But I want you guys to take account also the testimony that you heard from the defendant when he talked not only to the doctor, but he talked to the police, right? When he was questioned, he admitted that he did it. He admitted that he inflicted by popping him in the face because he cussed out at him, by being a kid. He admitted that he threw water at his own child. And you saw those burns on Danilo. You saw that they weren't caused by Danilo himself. You also saw that those were the incentives that this defendant was giving or trying to make Danilo exercise more and more throughout the day. You have his admission that he made Danilo exercise for at least 5 hours. And if he wasn't doing it, he would do it all over again. And he would add more time. And so we do truly believe that we have broken down all of these elements and have proven them beyond a reasonable doubt in each and every count that is before you. And so, whenever you are back there, I want you guys to think about all of that and rely
cannot stand up here and tell you that there was a good reason for all this, because there really wasn't. But what I can do is tell you that the instructions for what you need to do are contained here. And these instructions will tell you what to do in this case. There are many counts, and what it's going to ask you about is the difference between bodily injury and serious bodily injury. And that's something you have to make a distinction on to decide this case. But it's also going to ask you about the state of mind of my client. Did he knowingly do all this as far as knowing what the outcome was going to be? Or was he reckless doing it? Now, there's two pieces of evidence the state admitted that I think show his state of mind. And one of those pieces of evidence is the video from the doctor's office. In that video, my client, which shows the state of mind, not the ultimate good and bad of the case, but he's telling someone that he told his child that I'm bringing you to a better place. I'm bringing you to here, instead of Chicago. I mean to have a better place for you. So he's not saying he meant to kill him. And in fact, the DA did not bring this case as a murder case because we don't know the condition of the child before he came to him. We don't know who else was involved. There's another co-defendant in this case, hasn't been tried yet. And we don't know who contributed what to what. So it's not a murder case. But it does mean, what is the state of mind? If it's knowingly and intentionally, that's a first-degree felony. And in those first two counts, that's what it's going to ask you. Now, if you, in the other video, in the video at the police station, my client tells the officer, this is the way I was raised. This is the way I was raised. And not everybody was raised that way. I wasn't. I was from a military family, and I got spanked and disciplined, but I didn't have to do what this child wanted to do. But he says in that video that that's how he was raised. And I don't think he had parenting classes in school. I don't think he was taught the real things that we need to know to be a parent. It doesn't make it okay, but it does show his state of mind at the time. Those two pieces of evidence. Now, the outcome is terrible. It's terrible. I don't dispute that. Whatever happens to this child and whoever contributed to that, this child is not here today. He's not going to be here. You heard good testimony as far as medical examiners, the autopsy reports, and I questioned them to the extent that I could, but I couldn't really contradict a lot of what they said. There was a couple things some other witnesses said that I didn't really think were that important, even though they may have been inconsistencies. Somebody was talking about having back injuries, and yet the whole time he was there, it seemed like he just saw the front of his body. But that's not as important as what this issue is today. This issue today is to find him guilty or not guilty on these counts, and to also consider the lesser included accounts, which are the state of mind. If it's not knowingly, if it's not intentionally, that's a lower state of mind. If I have a ladder in my house, and it has a total of 12 steps, and I tell my wife, this ladder has 12 steps, that's a true statement. If I say the ladder also has 11 steps, that's also a true statement. Because anything less than that total ladder is true. It has 5 steps. And that's the way lesser included offenses work. It just means that it's an offense, and the state has proven all those elements, but there's one there that is not proven. For example, the state of mind, that he did it knowingly or confused, but it does show a steady line. So thank you for your participation and all of your answers right here.
Steve?
Let me just go ahead.
Yes.
How much time on this?
Yeah, 10 minutes.
Sure. Bring my child to a better place. Bound, beaten, hurt. What did the defendant say? Anybody who would listen. In the hospital. I whooped my son's butt. Not an ounce of regret in his voice. He's talking to the detective. And the anger slap popped him in the mouth. The detective confronted him. Burns. Danilo's buttocks that you saw. What do you say? Okay. Blood on the rug. Beat. Whipped. I didn't hear an ounce of regret. A few things that we can say for sure. Not only does the defendant beat his son in all of these ways, forced him to exercise for 5 hours until those toxins from muscle breakdown built up so much in his blood that he died. Like Dr. King said, the time he got to the hospital, that damage was done. It was over for Danilo Coles. We also know that those injuries did not come from his family in Chicago. He was abused up there. According to the defendant, his son was both physically and sexually abused in Chicago. But none of these injuries came from there. None of these injuries go back far enough. Dr. King told him none of them go back past January 3rd when this defendant picked up his son. And something else the defense said during closing that is true is that Derrick Coles didn't mean to kill his son. Because that wouldn't be this injury to a child, serious bodily injury. That would be murder. With Danilo Coles being 12 years old, that would have been capital murder. And if we thought that this defendant had done all of this intending to kill Danilo, he would be charged with capital murder. So what did he intend to do? Well, we know that he intended to keep him exercising all day. He told us that. And I want you guys to think about what it feels like to be in stress position, something like a push-up position or a plank. 30 seconds feels like forever. A minute, it starts to hurt. 5 or 10 minutes, grown adults can't keep doing it. It's agony. And he made his son do it, according to him, for 5 hours. That's not discipline, that's torture. That's what he meant to do to Danilo. That's what he intended to do. And he knew, because he had to know, serious bodily injury would follow. That kind of prolonged forced exertion. He knew that there would be scars and disfigurement from that scalding water he poured on Danilo to keep him going. He knew there were possibilities of causing serious damage to members and organs, like we talked about, from striking a child that age, that size, that hard, with that many implants. Danilo Coles died in pain on the worst day of his life. Danilo Coles had a lot of bad days in his life. He was only with the defendant because he found his grandmother, the only person who was caring for him, dead in bed.
ladies and gentlemen, that concludes the arguments of council. It is time for you to deliberate. You'll follow the deputy and commence your deliberations and select your foreperson, okay? Thank you.
All right, here.
you know